Hello, I'm Betsy Abramson. I'm an attorney and the Deputy Director of the Wisconsin Institute for Healthy Aging. I'm pleased to spend these next few minutes with you talking about a very important issue, and that's guardianship. People often ask me what guardianship means, what it involves, why it's needed, and whether I think it's important for their family member. So what is guardianship? It's a court-appointed relationship. There's generally two kinds of guardianship. Guardianship of the person to make personal, healthcare, living arrangement kinds of decisions, and then financial guardianship, often called the guardianship of the estate, to pay bills, file insurance, etc., etc. So when is a guardianship needed? Usually there's a few factors that lead someone to pursuing a guardianship for someone. First, they believe the person's not competent to make their own decisions, either never was, or perhaps it's someone who has later progressively become incompetent through some kind of Alzheimer's or dementia or a stroke or some kind of accident that has done damage to their brain. So first is being not competent. Second is that the individual has important decisions to be made about where to live, what kind of health care they need, financial matters to be attended to. Third, it means that the individual either never was capable of or was capable but did not ever complete powers of attorney. So all those are situations where a guardianship might be needed. What does it involve? As I mentioned, it involves someone going through the court. In a guardianship case, there's three sets of rights that are involved in a guardianship. They are the rights that can be removed from the individual and transferred to the guardian to exercise for them. That's the rights to where you're going to live, what kind of care you're going to need. Are you going to accept that care? Do you say no to that care? It might be end of life, it might be therapies, it might be about entering a type of facility. The second set of rights are those that may be removed from an individual but cannot be exercised by the guardian. That's like the right to marry, the right to vote. And then the third set of rights are the rights that are never lost in a guardianship. An individual always retains the rights to meet with whomever they want, to exercise their objections, and be able to meet with a lawyer and discuss those. So a guardianship is not really something to be feared, but generally people would like to avoid having a guardianship. So you can do that by planning ahead. While you're still competent, meet with a lawyer and discuss what your issues are and think about completing a healthcare power of attorney and a financial or durable power of attorney for your financial matters. That way, you'll get to pick whom you want and let them know what the decisions are that you'd want made for you if you were unable to make them yourselves. If not, you will find yourself in a court-appointed guardianship situation potentially at some time. That's not the end of the world either. But wouldn't it be nice to take care of it ahead of time on your own terms?
Support for Next Avenue Moments is provided by the Helen Daniels Bader Fund, a Bader philanthropy.